Dear distinguished guests and conference attendees, hello. My name is David Chetcuti Dimech. This short presentation will detail the main issues and laws surrounding honeybee protection within the EU. More research on this can be found in a recently published paper co-authored by myself and 3 other Maltese researchers in the European Energy and Environmental Law Review, also available on ResearchGate. The main problem we are tackling in this presentation is how to protect the genetic integrity of honeybee subspecies in the face of hybridization through intercourse between different subspecies introduced in a given area. And this can, of course, lead to the extinction of the individual subspecies over time through pollution of the gene pool, which would have evolved to cope with the particular environmental conditions of the bee's native area. For those unfamiliar with the system, I would like to premise this intervention with a very simple explanation of how EU law works, because different pieces of EU law have different effects on how they bind member states, and it's important to be aware of these. I'm going to be limiting myself here simply to the pieces of EU law applicable to this presentation, and these are 3: treaties, regulations, and directives. Treaties are always applicable. They are the superior laws. In fact, regulations and directives are issued pursuant to the treaties, which empower the EU institutions to issue those kinds of laws. So treaties are always applicable, and therefore they can be directly enforced in local courts. You can depend on them directly in national law. And the same goes for regulations. For example, the GDPR. GDPR is immediately applicable word for word throughout the Union the moment it enters into force. On the other hand, directives, they are binding on member states like regulations and treaties, but contrary to regulations and treaties, they must be transposed into national law to be enforced at the national level. What does this mean? The provisions of a given directive must be adapted to national law and promulgated in national law. So the member state needs to issue an act of parliament or subsidiary legislation to regulate the area of law covered by the directive. Exceptionally, yes, a directive can, like regulations, have direct effect, but only if it is not transposed or badly transposed within a set amount of time. But this is not something we need to go into. Now, it is very important to note that there is no specific EU law on honeybees. Does this mean they are not regulated? No. But in order to determine how they should be regulated, you need to look at the different EU laws dealing with the protection of biodiversity and then use these to determine whether honeybees can or should be protected according to EU law. The applicable laws my colleagues and I have identified in this regard are 4. The Treaty on the Functioning of the European Union, TFEU for short, the Habitats Directive, Invasive Alien Species Regulation, and the Rio Convention on Biological Diversity. I'm now going to review each briefly before answering the main question of whether honeybees should be protected at member state level according to EU law. The TFEU, as I mentioned earlier, it's a treaty, so it is the most superior law, and this treaty provides for how the EU should function. In fact, the Habitats Directive and the Invasive Alien Species Regulation are both issued by the European Commission pursuant to certain provisions of the TFEU, which empower the EU to take measures to further its policy on the environment. But, and this is important to note and we'll get back to it, member states can adopt more stringent measures so long as they are compatible with the treaties. So in most cases, while environmental policy laws by the EU set a minimum, member states can regulate the area more strictly as long as it is not contrary to the specific EU law. The other applicable provisions of the TFEU are Articles 34 and 36. These deal with importation of goods between member states, so across internal frontiers of the Union. As a rule, there can be no prohibition on the importation of goods within the EU due to the free movement of goods. So any measure that hinders the trade of goods is prohibited outright. But Article 36 of the TFEU provides for exceptions where these kinds of prohibitions are justified. There is no justification that specifically spells out protection of biodiversity or the environment per se, but a prohibition can be justified to protect, and here I'm quoting, the health and life of animals. The closer the relationship of the prohibition to the health effects on animals, the more likely it will be accepted as a justification, because of course the member state in question must prove to the EU that, listen, I need to take these measures in order to protect my honeybee populations. In fact, there is one judgment that was decided by the Court of Justice of the European Union that deals specifically with the prohibition of imports of foreign bee subspecies onto the Danish island of Leso in order to protect the Leso brown bee subspecies. And this is the Bloom case, decided in 1997. In this case, the CJEU found that while that kind of ban on imports was a prohibited act under Article 34, it was justified on the basis of Article 36 of the TFEU. Now I'm going to quote two excerpts from this judgment because it is quite instructive for what we're trying to figure out here. So the court held that measures to preserve an indigenous animal population with distinct characteristics contribute to the maintenance of biodiversity by ensuring the survival of the population concerned. By so doing, they are aimed at protecting the life of those animals and are capable of being justified under Article 36 of the treaty. And it then continued that from the point of view of such conservation of biodiversity, it is immaterial whether the object of protection is a separate subspecies, a distinct strain within any given species, or merely a local colony, so long as the populations in question have characteristics distinguishing them from others and are therefore judged worthy of protection, either to shelter them from a risk of extinction that is more or less imminent, or even in the absence of such risk, on account of a scientific or other interest in preserving the pure population as the location concerned. But the court also noted that any measures of the sort must be necessary and proportionate in relation to the aim of protection. So faced with two possible choices, option A and option B, a member state must always choose the less stringent measure, because again, free movement of goods is the norm. Any exception must be very, very, very contained and strictly regulated. Nevertheless, there is this judgment which proves that yes, measures can be taken to protect local bee species by prohibiting imports of foreign bee subspecies. Now, back to the other applicable laws. So the Habitats Directive protects habitats and species that are listed in its annexes. No bee features here, not one, but we need to remember that under the TFEU, member states can adopt more stringent measures, and therefore member state can, pursuant to the directive, protect its own bees and have its own list with species that are protected, such as a local bee. The directive also obliges member states to prohibit invasive alien species deemed of concern by them. Foreign bees can be considered to fall under this category. Likewise, the invasive alien species regulation allows member states to establish a list of invasive alien species and take measures to control or eradicate them as necessary. This list must be informed to the Commission, however. Under both Habitats Directive and regulation, however, you need to keep a list, so each and every bee that is intended to be prohibited needs to be listed there. Finally, the Rio Convention on Biological Diversity is part of EU law. Why? The EU is a party to it, and so it is automatically binding on the member states. The EU and its member states are placed under an obligation to develop national plans, policies and whatnot for the conservation and sustainable use of biodiversity, and to identify components of biodiversity for these aims. Local honeybee subspecies are very important from a sustainability perspective because the whole industry of apiculture depends on them, and they're also important ecological components on which ecosystems depend due to their pollination function. So it can be argued that honeybees can be protected under the Rio Convention as well. Before wrapping things up, I'm going to spend a few minutes on what is known as the precautionary principle. It's a basic principle of environmental law worldwide. It is essentially a risk management strategy that is employed, in the words of the European Commission itself, where scientific evidence is insufficient, inconclusive, or uncertain, and there are indications through preliminary, objective, scientific evaluation that there are reasonable grounds for concern that the potential dangerous effects on the environment, human, animal, or plant health may be inconsistent with the chosen level of protection. What does this mean? It is not necessary for there to be unambiguous scientific evidence that a given species, for our purposes, foreign bee subspecies, is harmful. Protective measures can also be taken if there is a strong suspicion that the species in question poses a health threat, even if it poses a health threat to other species that are desirable of protection. In fact, a scientific risk assessment is not even necessary for the taking of measures on the basis of the precautionary principle, and neither does it require the possibility of extreme irreversible hazard or the taking of urgent measures. And various legal authors on EU environmental law accept this. You can preempt in order to protect if, on a prima facie basis, local bees therefore are threatened through the importation of foreign bees because the gene pool is contaminated. Now, to sum things up, there are three possible routes that are available to protect local bee subspecies as essential components of biodiversity. Of course, we need to keep in mind that any approach must involve measures that are necessary and proportionate, as the Bloom judgment held. I have already indicated one of these methods, which is listing of foreign bee subspecies as invasive alien species under the Habitats Directive and the Invasive Alien Species Regulation. However, this is clearly impractical because it involves listing each and every subspecies. This means it must be constantly revised and updated as new strains or subspecies are discovered or appear in a given area. It can give rise to loopholes if a given subspecies is, for some reason or other, left out of the list, because this means that it can still be imported. So it is not a very clean solution to the problem. The second route is to ban imports of non-native bee species on the strength of Article 36. This achieves the same effect as banning under the directive and the regulation, but it doesn't involve keeping a list of species. So instead of checking whether the bee that you want to import is on the list, you need to determine that it is not a protected bee. So of course, instead of checking one long list, you only have one species, subspecies, with which to verify, which makes things much easier, and you are avoiding the issue of certain subspecies being left out of the list for some reason or other. The third route is member state specific, depending on laws that member states decide to promulgate on the basis of applicable EU laws. So, for example, Slovenia was already enforced before they entered into the EU, but they have kept it, and other member states do the same thing. It designates national species. In Slovenia, the bee is actually a protected species under national law, and that is one way that the bee can be protected. For example, Spain protected the canary black bee through specific protective measures. What can we conclude from what we have seen so far? Firstly, EU member states are under legal obligations to protect native honeybee species and subspecies through the general duty to protect their own biodiversity and also as an economic asset. And this protection, secondly, can only be effectively achieved through eradicating foreign subspecies and prohibiting their importation on the strength of Article 36 of the TFEU, in conjunction with the precautionary principle. Why? As you have seen, there is no other reasonable way of preventing different bee subspecies from procreating together and therefore hybridizing the gene pool once introduced in a given area. These aren't like sheep and pigs that can be penned off. Once they're in a given area, they will procreate freely in the air. And so there is no other measure that can effectively prevent that kind of effect. Finally, other EU laws and international law and possibly national laws allow for the taking of preventive measures to protect native honeybee subspecies from extinction through hybridization. So bottom line is that while there is no EU law specifically protecting honeybees, by interpreting the applicable laws, it is clear that if a given subspecies is threatened through hybridization with foreign bees that are being imported into a given area, then it is justified for the member state to take action to prevent the importation of those kinds of foreign subspecies and also eradicate colonies that are in the member state's territory. On that note, and that's the end of this short intervention. Thank you for your attention, and I wish you the rest of a good conference. Goodbye.